Hi, everybody. I'm Maggie Leone. I'm the Human Resource Generalist for CrossPoint Clinical Services. And today, what I'm going to do is present a video on sexual harassment prevention for employees. Sexual harassment training is important for many reasons. However, sexual harassment training is not required under state law. However, many states have enacted legislation specifically requiring sexual harassment training. Massachusetts does not require sexual harassment training, but it does strongly encourage it. So even if it's not a state requirement, the Supreme Court landmark decisions in 1998, which is Farger and Outlet sexual harassment cases, subsequent court decisions in the EEOC guidelines make it clear that sexual harassment training is essential. These court cases basically created a defense for employers that allow an employer to escape liability for actionable sexual harassment if it can show that an employer had a policy against harassment with a procedure for making complaints, but the victim of harassment did not complain using the procedure. So this presentation provides you with information. How do we recognize sexual harassment? We're going to review what our company policy is and the procedure on reporting sexual harassment concerns. So the agenda for this training is: what is sexual harassment? Why is it important to prevent sexual harassment in our workplace? Our policy and procedure on sexual harassment and your responsibilities. So what is sexual harassment? Sexual harassment is unwelcome sexual advances. However, there really should be no sexual advances in the workplace, welcome or otherwise, for obvious reasons, and also because, and I've seen this happen before, where two employees are having a consensual conversation about sex, and one person gets mad at the other person at a later date and then alleges that it's sexual harassment, and that person got in a lot of trouble. So if you wouldn't say it to your grandmother, then do not say it at work. Sexual harassment also is request for sexual favor. It's also anything that's verbal and written, electronic, or physical conduct of a sexual nature, but it has to rise to the level where it affects an individual's employment. It unreasonably interferes with his or her work performance, so usually it's more than a one-time occurrence, unless it is something very severe, or creates an intimidating, hostile, or offensive work environment. There are two forms of sexual harassment. One of them is quid pro quo, which is Latin, which means this for that or something for something. And that is a more severe but less common form of sexual harassment, and it always involves someone with more power sexually harassing someone with less power. The second form of sexual harassment is a hostile work environment. That's more common. That's usually coworker to coworker or employees that have equal power. Quid pro quo form of sexual harassment, like I mentioned before, is a more serious form of sexual harassment, and it involves someone with more power sexually harassing someone with less power. So it is a more severe form of sexual harassment because it's a supervisor harassing their subordinate. Supervisors are held to a higher standard when it comes to sexual harassment. And usually when it does happen, you'll see it in the news. Over the years, there have been news stories about sexual harassment lawsuits with Burger King, Starbucks, Fox News, There was a big story with NBC, if you remember, with Matt Lauer. More recently, Governor Cuomo of New York has a big, huge scandal on sexual harassment. And usually this form of sexual harassment involves monetary loss or job change. So in other words, if you do not go out with me, then you're fired. Things like that. There's an example here of Mary Smith receives smaller pay increases based on performance than other employees with similar performance because she refused to go out with Supervisor John Doe. The second form of sexual harassment is a hostile work environment. A hostile work environment form of sexual harassment is a more common form of sexual harassment. It's a coworker to coworker type of harassment, and it's some people that share equal power. The legal definition of a hostile work environment is speech or conduct that is severe or pervasive enough to create an abusive or hostile work environment, and it has to rise to a level where it unreasonably interferes with someone's job performance. Example, Mike Maloney is leering at and intentionally brushing up against Sally Davis. Now in this example, Sally Davis probably hates coming to work. She probably hates her job. And because of that, she's probably not doing a great job. So it is unreasonably interfering with her job performance. So that probably rises to the level of a hostile work environment. However, let's just say Mike Maloney only leered at Sally Davis once. Then that most likely doesn't rise to the level of a hostile work environment because it's not going to unreasonably interfere with their job performance. Now, people do misunderstand what a hostile work environment is. A hostile work environment is not just created because of a sexual harassment. It can be created because someone is a member of a protected class. So if someone is a member of a protected class and they're being abused or they're being harassed because they're a member of this protected class, then that's an illegal hostile work environment. You may be asking yourself, what exactly is a protected class? Well, protected class is race, color, religion, national origin, sex, which includes gender, pregnancy, sexual orientation, sexual identity, age, physical or mental disability, veteran status, genetic information, citizenship. So if you're a member of one of these protected class and someone is harassing you because of that, then that again is an illegal hostile work environment. Another misunderstanding of a hostile work environment is people think a hostile work environment can be created because someone's being mean to you. That is not an illegal hostile work environment. Unless they're being mean to you because you're a member of a protected class. I'll give you an example. A while ago, where I worked, someone was trying to sue their supervisor because they said they created a hostile work environment. Now, this supervisor was horrible to this person. She was mean to her, condescending, embarrassed her, especially in meetings where she would literally scream at her. But this is not a hostile work environment because her supervisor wasn't displaying this behavior because she was a member of a protected class. So she wasn't doing it because of her race or age or gender identity or citizenship. She was doing it because that was her style. That's how she rolled. And she wasn't just displaying this behavior to this particular employee. She did it to everybody, all of her subordinates. So basically she was an equal opportunity harasser. So even though it's unprofessional, it's uncomfortable, it's not a hostile work environment. So how this should be addressed is that person or that supervisor should have disciplinary action And if she keeps being retrained and things like that, and if she keeps displaying this behavior, then it would be termination, but it doesn't rise to a level of a hostile work environment. In addition to speech or conduct, a hostile work environment also covers explicit or suggestive items that are emailed, text, electronically provided, or displayed in the workplace that interfere with job performance or create an abusive or hostile work environment. An example is Jill Jones texts and instant messages her coworkers with sexually explicit jokes and pictures. Who can commit sexual harassment? Well, obviously employees at all levels. Also customers or vendors. So if someone's coming to deliver something, like the mailman or something, and they're sexually harassing the receptionist, then the mailman, actually, even though it's not the employee, it still could be considered sexual harassment. Also, members of the same sex or members of the opposite sex, so it can go in any direction. Who can be a victim of sexual harassment? Individuals or individuals targeted by statements or actions, bystanders or witnesses not directly targeted. So if someone is in a position to overhear a conversation that they think is offensive, they can be victims of sexual harassment even though no one is directly speaking to them. Then again, remember, it has to rise to the level of unreasonably interfering with someone's job performance. So in this situation, it would usually be where it would be like a daily thing. So maybe it's someone that is situated, or their desk is right near someone else who's on the phone talking to someone about sex. So even though someone isn't talking to them, they can still be a victim of sexual harassment. Why is it important to prevent sexual harassment in our workplace? It's important because sexual harassment does harm us all. So, for example, if a supervisor is sexually harassing a subordinate, everybody's affected by that. The person that's being sexually harassed, just say, for example, the person that's being sexually harassed is asked by the supervisor to sleep with them and they'll get a promotion. And say the person does sleep with their boss and they do get a promotion, then the other people are a victim of sexual harassment too, because they didn't get a promotion even though they might have been more qualified. A hostile work environment isn't just going to affect the person that's the victim, it's going to be the whole office or the whole organization. Also, the most important part of our values at CrossPoint Clinical Services, because we are a Christian organization, is we want to make sure that we treat everybody with dignity, and we want to treat everyone with respect. We want to create an environment of healing for our clients. So it's against everything we really stand for. Also, engaging in, condoning, or not reporting sexual harassment is a direct conflict with our values. If someone is engaging in sexual harassment or not reporting it, then they're part of the problem because they're allowing it to continue. And also, we want to remain compliant with Title VII of the Civil Rights Act. And Title VII prohibits sex discrimination, which includes sexual orientation, gender identity, gender expression. And we want to remain in compliance with all similar state civil rights laws and fair employment laws. As you know, we do have a sexual harassment policy and procedure here at CrossPoint Clinical Services. If you want to refer to it and you do not know where your copy is, there is a copy on the SharePoint. You can always contact me and I'll be more than happy to get you a copy of our sexual harassment policy. But here I'm going to go over the policy with you. complaints of harassment. So just say you are a victim of sexual harassment, or you happen to know someone that is a victim of sexual harassment, you witnessed it, then what you want to do is you want to report it. Now, just say, for example, you don't feel comfortable reporting it to your supervisor because maybe it's your supervisor that's harassing you, and then you can always go to another manager, or you can always come to me in human resources to report it. And whenever there is a complaint of sexual harassment, there is always an investigation. It's done promptly right away. So as soon as it's reported, it is investigated thoroughly. It is as confidential as possible, but please remember that other people, usually in an investigation, more than one person is interviewed. So if someone reports it, then maybe if there's potential witnesses or in the harasser, it has to be interviewed. So, but that would be kept very, very confidential. Also, depending on the outcome of the investigation, there's disciplinary action. Now that disciplinary action can vary greatly depending on the outcome. So it could be disciplinary action, it could be termination. Now there is a no retaliation law, so if someone reports sexual harassment, and honestly is anything, if someone reports anything, they can't be retaliated against. So no one has to worry about anything negative happening to their terms and conditions of employment. Your responsibilities as employees is to know and comply with our policy and procedure, report incidents that you experience directly or witness, cooperate with investigations, and support victims. So, in summary, sexual harassment is unwelcome sexual advances. Remember, there should be no sexual advances in the workplace. Requests for sexual favors and other verbal, written, electronic, or physical conduct of a sexual nature that affects an individual's employment, unreasonably interferes with his or her work performance, or creates an intimidating, hostile, or offensive work environment. And remember, a hostile work environment isn't just based on sex, it's based on any protected class. So remember, there are two forms of sexual harassment. One is a quid pro quo form of sexual harassment that involves someone with more power sexually harassing someone with less power. The second type of sexual harassment is a hostile work environment, which is people that have equal power, so it's co-worker to co-worker. And just so you know that supervisors are held to a higher standard when it comes to sexual harassment. So if a supervisor knows about a sexual harassment situation, then they're required by law to do something about it. So they can't just let it go. So it would be wise to report a supervisor to report a situation that they may know about to the Human Resources Department. And also remember, it's important to prevent sexual harassment in our workplace because it does harm us all, and also conflicts with our company values that everyone should be treated with dignity and respect. Sexual harassment is illegal under federal law and state law. Your responsibility regarding prevention of sexual harassment is to know and comply with our sexual harassment policy and report any incidents that you experience or you witness. Cooperate with any investigation and support victims. So if you have any questions about sexual harassment, about our policy, about our procedure, if you want to report any incidents or just discuss something, that I'm more than available and more than happy to sit down and discuss anything with any employees. So just reach out to me. Again, I'm Maggie Leone. Thank you so much. Bye-bye.